We have breaking news out of Ohio. The verdict in the medical assistant murder trial for Quinton Nixon has come in.
This is a bench trial, so the judge is on the bench. Let's go back. Let's go into the courtroom in Ohio and see what she has decided about the defendant's fate.
There will be no outbursts of any kind, and if there are, you will be asked to leave the court and not return until this court is done with its business. Thank you. Let me start by saying, Mr. Nixon, I'm going to commend you for your behavior throughout the trial. You were very respectful of the process and the court. That being said, I do believe you did a great and grave disservice to yourself by representing yourself. There are many nuances and trial strategies that a seasoned attorney such as Mr. Perry would have been able to employ throughout this trial. That being said, having decided to represent yourself and waive your right to the jury trial, the responsibility falls on me to render verdicts in these cases. In the case involving the death of Toni Westover, in count one, you are charged with murder in that the state must prove that you purposely caused the death of Toni Marie Westover with a firearm specification attached. Purpose to cause the death of Toni Marie Westover is an essential element of the crime of murder. A person acts purposely when it is his specific intention to cause a certain result. It must be established in this case that at the time in question, there was present in the mind of the defendant a specific intention to cause the death of Toni Marie Westover. Purpose is a decision of the mind. To do an act with a conscious intent to produce a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances and evidence. The defendant is allowed to use deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using deadly force, did not act in self-defense. To prove that the defendant, when using deadly force, did not act in self-defense, the state must prove beyond a reasonable doubt at least one of the following. The defendant was at fault in creating the situation, giving rise to the shooting or attempted shooting of Toni Marie Westover, or the defendant did not have reasonable grounds to believe that he was in imminent danger or death or of great bodily harm, or the defendant did not have an honest belief, even if mistaken, that he was in imminent danger of death or great bodily harm, or the defendant used unreasonable force. Unreasonable force is a person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. If the defendant used more force than reasonably necessary, and if the force used is so greatly disproportionate to the apparent danger, then the defense of self-defense is not available. Greatly disproportionate. In deciding whether the force used was greatly disproportionate to the apparent danger, I must consider whether the force used shows revenge or a criminal purpose. In count two of and I will add that the defendant has alleged self-defense in all three counts, counts 1, 2, and 3, in the indictment. In count two, the defendant must have caused the death of Toni Marie Westover as the proximate result of committing or attempting to commit felonious assault, also with a firearm specification. The state must prove the elements of felonious assault as to the murder contained in count 2 of the indictment, as well as all of the elements of felonious assault. Felonious assault, the defendant must have knowingly caused or attempt to cause serious physical harm to Toni Marie Westover by means of a deadly weapon, to wit, a firearm. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Knowingly means that a person is aware of the existence of facts, that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. In addressing whether your actions were in self-defense, I find that the state
What are you doing? Everyone knows that stupid game isn't real.
It's called Last War. It's going viral.
must find, or the state must prove that there was serious physical harm, which is any physical harm that carries a substantial risk of death. In count 5, because count 4 was dismissed prior to the trial beginning, the defendant must have knowing that an official proceeding or investigation was in process or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence. For each of the charges contained in counts 1 through 3, there are also attendant firearm specifications. The state must prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing those offenses and displayed the firearm, brandished the firearm, indicated that he possessed the firearm, or used it to facilitate the offense. Firearm means any deadly weapon capable of expelling or propelling one or more projectiles by the action of explosive or combustible propellant. Firearm includes an unloaded firearm and any firearm that is inoperable, but that can readily be rendered operable. When deciding whether a firearm is capable of expelling or propelling one or more projectiles by the action of an explosion or combustible propellant, I may rely on circumstantial evidence, including but not limited to the representations and actions of the defendant while exercising control over the firearm. As to the charge of improper handling of a firearm in a motor vehicle, in case 2206-2276, the defendant must have knowingly transported or had a loaded firearm in a motor vehicle in such a manner that it was accessible to the operator or any passenger without leaving the vehicle, and the accompanying forfeiture specification of the Riley Defense, Inc., RAK 47, serial number B11765. I've carefully considered all of the evidence and the exhibits admitted during trial. I've weighed the credibility of the testimony of all the witnesses, including the testimony of the defendant. It is my province to believe all, none, or some of the testimony of each witness, as well as the physical evidence that has been presented and the exhibits admitted during trial. I have considered the physical evidence and whether it corroborates the testimony of each witness in deciding which, if any, of their testimony I choose to believe. I find there is no credible evidence that Ms. Westover threatened or even tried to harm the defendant. There was credible evidence that the defendant had hold of Ms. Westover either by, as to her upper torso, whether by her hair, neck, or shoulder. Ms. Westover was shot 3 times, and the most serious injury which caused her death was a gunshot wound to the back of her neck that was approximately 8 to 10 inches away and included evidence of stippling near the entrance wound, and the trajectory of that propellant was from back to front, right to left with a downward angle. While the defendant's testimony at times was believable, and there were portions of his testimony that he seemed genuinely convinced of the testimony he was presenting, I find a majority of that testimony was completely self-serving, illogical, and completely uncorroborated by the physical evidence and exhibits admitted during trial. In reviewing Exhibit G of the defense's exhibits, there was no credible evidence that you were injured or that your clothes were torn by Mr. Cruz, the machete-wielding aggressor. While you fled the scene, both Adam Wright and Brian Fielders had already both fled, and you still possessed the firearm. Furthermore, once you dropped from the porch, you leisurely strolled away with no signs of panic or fear that you testified you were feeling during the trial. Your statements to detectives the night you were arrested contained various inconsistencies, not to mention were completely inconsistent with your testimony during this trial. Lastly, your actions in fleeing that night with Ms. Westover's purse and the firearm, and changing your appearance and hiding out in your cousin's house for over a month shows a consciousness of guilt. This court is left to weave together the offensive events of July 25th, 2022 from all the testimony, the physical evidence, and the exhibits admitted during trial. Based on everything presented at this trial, the more logical sequence of events is that for whatever reason, including being high on methamphetamine, not having slept for days due to that methamphetamine use, and the paranoia that comes with the use of methamphetamines, you shot and killed Toni Westover. And after shooting her, you were attacked by Brian Fielder, and when you had him down on the floor, he bit you while trying to get the gun away from you and from your grasp. According to Ashley Bratton, who testified 2 times, and including yesterday, Adam Wright was on his way out of the back bedroom with a firearm and returned, and upon finding you on top of Brian Fielder, hit you with the firearm and then fled. Everyone fled through that back bedroom because Toni Westover was left dead, hanging over the side of that couch, and was blocking the front door. Therefore, I'm left with only one conclusion. The state of Ohio has proved beyond a reasonable doubt that you committed the crime of improper handling of a firearm in a motor vehicle on June 5th, 2022. And furthermore, by clear and convincing evidence, I'm ordering forfeiture of the Riley Defense, Inc. RAK 47. As to all the charges in the indictment in case 2209-3102, I have considered each count uninfluenced by my verdict as to any other count. And I find that the state of Ohio has proved beyond a reasonable doubt that you did not act in self-defense on July 25th, 2022, and that you were at fault in creating the situation, giving rise to the shooting, or attempting to shoot Toni Marie Westover, and or that you used unreasonable force against Toni Westover. Therefore, I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 1, and the 3-year firearm specification 1 to count 1. I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 2, as well as the firearm specification 1 to count 2. I find you guilty beyond a reasonable doubt of felonious assault, a felony of the 2nd degree, as contained in count 3 of the indictment, and the firearm specification 1 to count 3. And lastly, I find you guilty beyond a reasonable doubt of tampering with evidence as a felony of the 3rd degree, as contained in count 5. The court having rendered its verdict, I am prepared to proceed to sentencing at this time, if both parties are prepared also. Before hearing from the parties, I do find pursuant to Ohio Revised Code 294125, State versus Johnson and State v. Ruff, that counts 1, 2, and 3 for merge for purposes of sentencing. I find that the defendant's conduct is of similar import and was committed with the same animus. Pursuant to Ohio Revised Code 292914B1G, if an offender is convicted of or pleads guilty to 2 or more felonies, if 1 or more of those felonies are aggravated murder, murder, attempted aggravated murder, aggravated robbery, felonious assault, or rape, and if the offender is convicted of or pleads guilty to a specification of the type described under Division B1A of this section, in connection with 2 or more felonies, the sentencing court shall impose on the offender the prison term specified under Division B1A of this section for each of the 2 most serious specifications of which the offender is convicted or to which the offender pleads guilty, and in its discretion also may impose on the offender the prison term specified under that division for any or all of the remaining specifications. Therefore, I find that specifications to count 1, 2, and 3 do not merge pursuant to 292914B1G. Mr. Perry, would you like to talk to Mr. Nixon about a PSI or